This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when a defendant turns down a plea agreement, goes to trial, and is convicted, and finds out that when you do the crime, you must do the time. And that when a conviction by a jury, you don't get the plea agreement you turned down because you gave up that right when you demanded trial. Thomas Scher was convicted of healthcare fraud and conspiracy to commit the same. The district court sentenced him to 96 months imprisonment. Scher appealed his sentence, arguing that the court erred in its loss calculation and in its application of a sophisticated means enhancement. In United States of America versus Thomas Scher, the United States Court of Appeals for the Third Circuit on August 1, 2024, dealt with the felon's claims for a shorter sentence. Scher worked as a firefighter with the Margate Fire Department from 2003 to 2019, and as a fitness trainer beginning in 2014. In 2015, he joined an ongoing conspiracy to commit insurance fraud by convincing acquaintances with state-provided health insurance plans to purchase medically unnecessary compound medications. At the center of the conspiracy was Central Rexall Drugs, Inc., a Louisiana-based compounding pharmacy that produced the medications. CRD paid commissions to pharmaceutical sales representatives, specifically William Hickman, for each prescription that he or those working for him originated. Hickman enlisted recruiters, including Scher's brother Michael, and instructed them to target individuals with state-provided insurance plans and sign them up for the maximum number of refills. The recruiters were paid a percentage of Hickman's commission based on the amount of prescriptions they sold, and the recruiters in turn enlisted and paid commissions to their own pods of sub-recruiters. As a sub-recruiter in Michael's pod, Scher was at the lowest level of the conspiracy. In furtherance of the conspiracy, Scher approached friends and family about purchasing wellness supplements made by CRD, offering cash payments and free gym memberships as incentives. Scher instructed the individuals he enrolled to fill in demographic and insurance information on pre-printed prescription forms and then sent the forms up to the chain, Michael, and eventually to Hickman. Hickman then arranged for a doctor to sign the forms, often without evaluating the patients. In total, Scher submitted prescriptions for 18 people, causing $936,889.28 of fraudulent insurance reimbursements, while Michael's pod was responsible for $7,059,888.28 of fraudulent reimbursements. A very lucrative scheme. After a jury trial, Scher was convicted on 4 counts of healthcare fraud and conspiracy to commit the same. The probation office prepared a pre-sentence report in which it calculated a total offense level of 31 and a criminal history category of I, resulting in a guidelines range of 108 to 135 months imprisonment. As relevant to Scher's appeal, the PSR, the pre-sentence report, applied an 18-level enhancement for causing a loss between $3.5 million and $9.5 million, and a 2-level enhancement for use of sophisticated means. The pre-sentencing report explained that because Scher conspired and jointly engaged in healthcare fraud with his brother, the loss amounts associated with Michael's prescriptions were within the scope of the jointly undertaken criminal activity and reasonably foreseeable to Scher. At sentencing, Scher objected to the loss calculation, arguing it penalized him for exercising his right to trial. He also argued that the sophisticated means enhancement should not apply. The district court overruled both objections, and after applying a 2-level downward departure, resulted in an offense level of 29. The court sentenced Scher to 96 months imprisonment. Scher appealed, claiming that the loss calculation and application of sophisticated means enhancements amounted to unconstitutional trial penalties. First, in cases of jointly undertaken criminal activity, courts have considered as relevant conduct in the actions of others if they were 1, within the scope of jointly undertaken criminal activity, 2, in furtherance of the criminal activity, and 3, reasonably foreseeable in connection with the criminal activity. Second, Scher argued that the district court erred by applying a sophisticated means enhancement. The district court applied the enhancement based on the duration of the conspiracy, Scher's efforts to avoid detection, and the fact that the scheme involved 69 participants, among other factors that supported its application. Third, Scher maintained that the district court unconstitutionally penalized him for exercising his right to a trial. Scher was not punished for going to trial. He chose to forego favorable terms that his co-conspirators received in exchange for pleading guilty. However, the government offered Scher a plea deal that stipulated to a loss amount between $550,000 and $1.5 million, and Scher rejected that offer. The district court was not required to give Scher the benefit of a bargain that he had turned down simply because his co-defendants accepted similar terms. In my opinion, when a criminal turns down a favorable plea bargain and insists on trial by jury, the conviction required a sentence greater than the one offered before trial, and he must do the time the jury trial required. He cannot obtain a smaller sentence just because his co-defendants accepted much lower terms that were similar to what he was offered and turned down. When you do the crime, you must do the time. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And if you do, I'd appreciate it if you tell your friends and colleagues about the blog and the videos and let them subscribe as well. You can also subscribe to the videos. They're free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.